Ready, start. All that has been said in paragraph 5 bracket 1 and bracket 2 of the writ petition is a. That the respondent herein has been imposing and collecting various kinds of direct and indirect taxes from the petitioner and other citizens of the country full stop, that a part of the taxes so collected have been utilized for various purposes including promotion and maintenance of a particular religion and religious institutions full stop. Thus, it is nowhere mentioned in the writ petition as to what percentage of any particular tax has been utilized for the purpose of the Hajj pilgrimage full stop. The allegation in para 5 bracket 2 of the writ petition is very vague full stop in our opinion, if only a relatively small part of any tax collected is utilized for providing some convenience or facilities or concessions to any religious denomination, that would not be violative of Article 27 of the Constitution, full stop. It is only when a substantial part of the tax is utilized for any particular religion that Article 27 would be violated, full stop. As pointed out in para 4, 6 and 7 of the counter affidavit filed on behalf of the central government, the state government incurs some expenditure for the Kumbh Mela, the central government incurs expenditure for facilitating Indian citizens to go on a pilgrimage to Man Sarovar, etc. Similarly, in para 8 under bracket 7 of the counter affidavit, it is mentioned that the some state governments provide facilities to Hindu and Sikh pilgrims to visit temples and gurudwaras in Pakistan, full stop. These are very small expenditures in proportion to the entire tax collected, full stop. Moreover, para 8 under bracket 3 of the counter affidavit, the central government has stated that it is not averse to the idea of granting support to the pilgrimage conducted by any community, full stop. In our opinion, we must not be too rigid in these matters, and must give some free play to the joints of the state machinery, full stop. A balanced view has to be taken here, and we cannot say that even if one paisa of government money is spent for particular religion, there will be violation of Article 27, full stop, as observed by Mr. Justice Holmes, the celebrated judge of the US Supreme Court, in Bain Peanut Co. versus Pinson, the interpretation of constitutional principles must not be too literal, full stop. We must remember that the machinery of the government would not work if there were no allowed a little play in the joints, full stop. Hence, in our opinion, if it were no allowed a little play in its joints, hence, in our opinion, there is no violation of Article 27 of the Constitution, full stop. There is also no violation of Articles 14 and 15 because facilities are also given, and expenditures incurred, by the central and state governments in India for other religions, full stop. Thus, there is no discrimination, full stop, in Transport Dock Workers Union versus Mumbai Port Trust, 2010, this court observed that Article 14 cannot be interpreted in a doctrinaire or dogmatic manner, full stop. It is not prudent or pragmatic for the court to insist on absolute equality when there are diverse situations and contingencies, as in the present case under bracket wide paragraphs 39 and 43, full stop. Apart from the above, we have held in government of Andhra Pradesh versus P. Lakshmi Devi, AIR 2008 SC that court should exercise great restraint when deciding the constitutionality of a statute, and every effort should be made to uphold its validity. Full stop. Parliament has the legislative competence to enact the Hajj Committee Act in view of entry 20 to list one of the seventh schedule to the constitution which states pilgrimages to places outside India. Full stop. Thus, there is no force in this petition and it is dismissed. Full stop. Before parting with this case, we should like to mention that India is a country of tremendous diversity, which is due to the fact that it is broadly a country of immigrants under bracket like North America, as explained in detail by us in Kailash and others versus State of Maharashtra, JT 2011 under bracket 119 full stop, as observed in paragraph 32 of the said decision, since India is a country of great diversity, it is absolutely essential if we wish to keep our country united to have tolerance and equal respect for all communities and sects. Full stop. It is due to the wisdom of our founding fathers that we have a constitution which is secular in character, and which caters to the tremendous diversity in our country. Full stop. It may be mentioned that when India became independent in 1947, there were partition riots in many parts of the subcontinent, and a large number of people were killed, injured and displaced. Full stop. Religious passions were inflamed at the time, and when passions are inflamed, it is difficult to keep a cool head. Full stop. It is the greatness of our founding fathers that they kept a cool head and declared India a secular country. Full stop. Stop.